Hello guys, welcome to the channel. Today I am dictating you legal dictation 520 words at the rate 100 words per minute. So let's get started. 3, 2, 1 and go. Not for nothing, it has been said that sun rises and sun sets, light and darkness, winter and spring come and go. Even the course of time is playful, but truth remains and sparkles when justice is done. It is the bounden duty of a court of law to uphold the truth, and truth means absence of deceit, absence of fraud, and in a criminal investigation, a real and fair investigation, not an investigation that reveals itself as a shame on. It is not acceptable. It has to be kept uppermost in mind that impartial and truthful investigation is imperative. If there is indentation or concavity in the investigation, can the faith in investigation be regarded as the gospel truth? Will it have the sanctity or the purity of a genuine investigation? If a grave suspicion arises with regard to the investigation, should a constitutional court close its hands and accept the proposition that as the trial has commenced, the matter is beyond it? That is the tour de force close of the prosecution, and if we allow ourselves to say so, it has become ide fixe close. But in our view, the emporium of the constitutional courts cannot be stifled or smoothed by bon mot or polemic. Of course, the suspicion must have some sort of base and foundation, and not a figment of one's wild imagination. One may think an impartial investigation would be a nostrum, but not doing so would be like playing possum. As has been stated earlier, facts are self-evident and the grieved protagonist a person belonging to the lower strata. He should not harbor the feelings that he is an orphan under the law close. Suffice it to observe that we do not intend to deviate from the conclusion reached by the High Court that in the peculiar facts and circumstances of the case, it is but appropriate that investigation of the crime in question must be entrusted to CBI. Reverting to the last contention that the High Court should have been loath to entertain a public interest litigation at the instance of respondent number 14, who happens to be a member of the Legislative Assembly in the state of Tamil Nadu, or that he had participated in raising the issue in the Assembly, has also been answered in the impugned judgment. The court, while entertaining public interest litigation at the instance of respondent number 14, has relied upon the dictum in so and so versus Superintendent of Police and others, wherein it is observed that the political opponents play an important role both inside and outside the House and are watchdogs of the government in power. They are the mouthpiece to ventilate the grievances of the public at large, if genuinely and unbiasedly projected. Referring to this decision, the court noted in paragraph 70 of the impugned judgment that a petition filed by such persons, such as respondent number 14, cannot be brushed aside on the allegation of political vendetta if otherwise it is genuine and raises a reasonable apprehension of likelihood of bias in the dispensation of criminal justice system. Accordingly, The ground of challenge under consideration, in our opinion, is devoid of merits. Full stop and over. Thanks for watching. Please do like, share and subscribe the channel for more dictations, and don't forget to press the bell icon for future notifications.